Okay, this is part two of sort of the explanation of IEP meetings and how to best be prepared. The meeting notices is what I went through in part one, and how to fill out those forms and how to safeguard yourself. And part two is moving into the aspect of sort of the pre-meeting, and how do you best prepare in advance of your IEP meeting. And there's going to be a whole bunch of different kinds of parents and how they prefer that to happen. And there are some parents that are like, look, I really want that draft IEP, that IEP in advance, a draft copy of the IEP in advance in order to fully participate. That makes me comfortable as a parent. Okay. And a lot of parents feel that way. And there are some schools that are like, we don't give drafts out in advance. There's some schools that will sit there and say, you have a 30-minute block of time for your annual IEP meeting, and you'll have some schools that will provide a draft in advance. And I can tell you, each one of them are going to have a much different result with regards to the relationship that they have with their parents, depending on how they handle house cleaning, things like this, simple interpersonal relationships. And I can tell you, the schools that are the most transparent and will create an environment of reciprocal communication with their parents are going to have less of a problem than the ones that want to lock the information up, and the ones that want to be as mysterious as possible, or the ones that just want to be bullies and dictate because they're the government, and we don't have to do whatever, and the law doesn't make us do it. Well, guys, there's a lot of things that the law doesn't make you do that is just part of human decency, and it's just part of respect, because there's a lot of things within the law that are intentionally vague. It's intentionally ambiguous. And because the entire purpose is so that it provides the IEP team the sufficient flexibility to be able to properly serve a child in an individualized program. Okay, because you have Board of Education rules, you have state and federal government rules with regards to high stakes testing and how they want things done. You have all of these rules, laws, all these things. And the entire IDEA, Individuals with Disabilities Education Act, 504 to a degree, those things are there intended to be safety nets of flexibility on these very, very rigid laws that quite frankly is not individualized. So if you look at it from that perspective, that how can you individualize a child's education program with very rigid zero tolerance discipline policies, or very rigid high stakes testing policies? That's the entire point of accommodations. That's the entire point of modification. That's the entire point of supplemental aids and services. That's the entire point of specialized instruction, is it provides the flexibility that the IEP team needs in order to properly serve the child in an individualized fashion. There's not a lot within IDEA that would not trump the board's behavior policies, the high stakes testing rules. I mean, any kind of in-school policy. The IDEA crushes all of those in almost every respect. Like for behavior, for example, unless your child is in possession of drugs, and illegal drugs at that, causes serious bodily injury as it's defined by the federal law, or has a weapon like a gun at school, and schools really try to define what the definition of a weapon is. Those three things are about the only things that would trump IDEA with regards to your child's rights of protection due to behavioral infractions or whatever. Okay, so you sit there and you apply that rule across all of the areas. It's intentionally vague, it's intentionally ambiguous in a lot of these rules in order to provide the IEP team with what it needs to properly serve the child. So let's go on to and have a little discussion about this. What I have pulled up is called the Federal Register. Okay, and this is where, I mean, it's thousands and thousands and thousands of pages, guys. And what it does is it takes the Individuals with Disabilities Education Act and it breaks down each section and sort of explains, has sort of a commentary and any recommended changes that is recommended when it comes to that. Okay, so what I wanted to concentrate on is sort of this area over here. With respect to a draft IEP, we encourage public agency staff to come to an IEP meeting prepared to discuss evaluation findings and preliminary recommendations. Likewise, parents have the right to bring questions, concerns, preliminary recommendations to the IEP team meeting as part of a full discussion of the child's needs and the services to be provided to meet those needs. We do not encourage public agencies to prepare a draft IEP prior to the IEP meeting, particularly if doing so would inhibit a full discussion of the child's needs. Okay, now I'm going to go into the rest of it, but let's discuss that to this point. Okay, now up here, what they want and the whole idea behind this is that there's one big no-no in the law, and that is coming to a meeting with a preconceived determination or predetermining a child's placement and a child's services. Okay, so that's sort of the cautionary approach, with regards to creating a draft IEP. Oh, because at that point, what the intent of the law is in order to develop a very good IEP that's individualized for a child, well, it might not be a good idea to already have everything filled out, even in a draft form. Now, at the same time, in the realistic world that we live in, there's only so much time in a day, and in order for an IEP team to truly do its job, it would require hours upon hours to build an IEP from scratch. It really would. So at that point, a lot of the schools will create the drafts in advance and have it there. Now, what the recommendation is, or what the concern is that we just read, that's the entire purpose, is that the law does not want the school coming to this meeting with a preset idea of goals, preset idea of present levels of performance, preset ideas on services. Now, why is that? Because those things absolutely directly impact what a child's least restrictive environment is. Those determinations made in advance end up filtering over to the very last thing, because all of this stuff is a buildup to what a child's least restrictive environment is. And that is dancing and playing with predetermination. And we don't predetermine a child's placement. We don't predetermine a child's services. But does that happen? Does it need to happen? Yes, I'm one of those people that believe that it's necessary. It is a necessary evil to have a draft IEP in advance. That is part of the reason I have this group, is so that you understand as a parent that, yeah, in a perfect world, we would love to sit there and create an IEP from scratch, but we only have, an hour or two. And as long as a parent goes into that meeting, and as long as it is thoroughly explained to the parent in such a nice, non-combative, collaborative fashion, that we put this in draft form, but any of it can be changed. Any of it. This is a starting point. This is a starting preview. But any of this can be changed. As long as that is conveyed and understood by the parent, then, guys, at that point, I don't have a problem with having draft IEPs in advance. because at that point, the parent understands, oh, okay, I don't like that sentence. I don't like how it's worded. Now, there's a lot of parents out there, and this is where if you are a special education director, if you're a case manager, you need to understand your audience. You need to understand the temperament and the personality of the parent of the particular child for an IEP meeting. Okay, because if you know that particular parent is non-combative and that parent does not, let's say that parent is timid or shy or uncomfortable, then guys, you're running a danger, because even though they disagree, they're not going to say they disagree because they don't want to appear combative. They're timid. They feel they don't feel secure in being able to voice a disagreement with your plan. And then what they end up doing is they end up calling me and they end up saying, oh, it was a horrible IEP meeting. It was terrible. And then we end up getting involved. We file a complaint. And then I find out later that the director's like, I was at that meeting, James, and the parent was shaking their head and the parent was agreeable. I had no idea that the parent felt this way. And what I end up having to tell the director is, did you bother to check their personality? Because you knew that this was not the type of personality. This wasn't the type of parent that is comfortable in these kind of meetings, is comfortable being challenged, or is comfortable being put on the hot seat with 7 other people that work for the school to sit there and say, hey, we made this draft. Do you like it or not? Because the parent's like, well, I don't want to offend anybody. You're the experts. I'm not. I don't necessarily like how that's worded, but, do I want these people not to like me? And that's a logical thing to think as a parent. Put yourself in the parent's perspective. And see, that's another danger of why the Federal Register, the people in the Federal Department of Education are advising, hey, it might not be a good idea, because it creates a lot of nuances. But like I said, it's a necessary evil. There's nothing wrong with creating a draft in advance. But this is where I think I think that this is where it separates. Okay, let's get back over to this, and I'm going to have to scroll up. All right. Okay. Now, however, if a public agency develops a draft IEP prior to the IEP team meeting, the agency should make it clear to the parent at the outset of the meeting that the services proposed by the agency are preliminary recommendations for review and discussion with the parents. And I don't think a lot of IEP teams do a good job at explaining that in advance. And so many parents that I talk to sit there and say, they don't make it sound like a draft, James. They refuse to give me a copy in advance to review. If you looked, if as a school system, I know that it says in some OSEP decisions, we don't recommend you giving drafts to parents. Well, it didn't recommend you create one in the first place, did it? But there's no law that says that you can't. And so a lot of you do as best practice, and it makes sense. But I understand that it also says, well, you don't, because there's some OSEP decisions that are like, you're just not good to share with the parent. It says that for the same reason it advises schools not to create a draft in advance, because the possibility of miscommunication, misunderstanding, misinterpretation goes up dramatically. And that's why it says that if you do this, you need to make it perfectly clear to the parent that this is just a preliminary recommendation for review and discussion, and that anything can be changed. But if you're going to go through that trouble of developing a draft IEP when the recommendation is that you don't, period, then what's the problem with sharing it with the parent in advance and putting draft all over it and highlighting the fact in handwriting that this is in fact, I would use this in exact language, that this is a preliminary recommendation for review and discussion, and that anything can be changed once the meeting starts. And so this provides the parent a snapshot of what it is that the school system is sort of recommending or looking at, really to save time and to channel the discussions. But I think it's smart to give the parent a draft in advance. Okay, the public agency also should provide the parents with a copy of its draft proposal if the agency has developed them prior to the IEP meeting, so as to give the parent an opportunity to review the recommendations of the public agency prior to the IEP team meeting and be better able to engage in a full discussion of the proposals for the IEP. All right. It is not possible for an agency to have the IEP completed before the IEP team meeting begins. Okay. I think that's what that says. Let me double check. Oh, it is not permissible for an agency to have the final IEP completed. Sorry. See, let me go ahead and show it to you. That final language. I want you to be able to see that because that's very important. It is not permissible for an agency to have the final IEP completed before the IEP meeting even begins. So there are many times that I've had cases over the years, guys, to where the parents sit there and say, well, they handed me this IEP meeting. They said that we had 30 minutes. They reviewed the whole thing and they wanted me to sign. There was no discussion. The parents didn't feel like they had any kind of input. These are also typically the same school systems that don't want you to record your meeting because they just don't want transparency. They don't really want your input. You're just a pain in their ass that they're required to invite. You can always tell who the bad leaders are. You can always tell where the incompetent leaders are and where the incompetent teachers are, where the bully teachers are. That's how that's how you can tell who they are. And it flies in the face of IDEA, guys. That's just not what IDEA is about. Okay? So the big takeaway from this is leading up to the meeting. What I would also recommend is you do not overdo it. There's a lot of parents out there that will have an entire, 20-page thesis on what it is that your child requires in order for them to make improvements based upon scientific data and peer-reviewed research, and that's what you want them to implement. And that's what you present is your 20-page thesis. And that's overkill, guys. It's too much. And you're not going to get a positive response from your school system if that is how you approach it. What you need to do is you need to chunk. IEP meetings and IEP teams, really, human beings by nature want to say yes, guys. We don't like to say no to people. We just don't. I know that people go, well, I hear no from IEP. Well, how are you doing it? Because if you can sit there and chunk your request, and if you understand how to communicate with other people and how to negotiate, which is really what I do all the time, then you're going to end up getting more yeses than you will believe. But if you go into your meeting with a piss poor attitude, soaked in negativity, then yeah, guys, sharks can sense blood in the water, and you don't want to sit there and show up at your IEP meeting with a negative attitude, with a charged attitude, with an aggressive attitude, because it is going to filter and be felt by everybody in the room. And if you sit there and go, well, that's how they show up to every one of my meetings. So, guys, there's nothing in this law that gives them any more power over you than what you give them. Okay? You need to understand that. And I know it's easy for me to say because I'm naturally sort of a combative personality. I guess an A-type. It just doesn't bother me. But I go into these meetings for my own child and for all of you guys. I already go in prepared with what needs to happen. It's up here. Sometimes I put it on paper. Sometimes I don't, because I try to understand the room that I'm going into. Okay? I try to understand the different personality types, the special education director, the particular school system, the attorney that's going to be there representing the school. That's why over the years of doing this, let's say in Alabama, where I've had the most mature practice, I know who the board attorneys are. All right. And I can sit there and tell you which one I'm going to have more of a positive outcome in a meeting with and who I won't. There are some good board attorneys out there in Alabama, for example, that they represent public schools, but they're not anti-child. And they're a benefit on the school side in order to work these things out, because they have an expertise in this law like I do, and they are trying to look at it from a collaborative viewpoint instead of a combative viewpoint. And so in the situations where those schools are represented by those board attorneys, they have less of a problem. I completely understand that I am along with the board attorney, I mean, we're sort of unplanned outliers in all of this. And schools hate attorneys, even their own. But this law provides the parent the right to get a professional like me involved when it's justified and necessary. And yes, as part of that, the law dictates that the school system is responsible for reimbursing or paying for the parent's attorney's fees if the reason that they got this attorney involved in the first place was justified, and corrective action is such to where it made a change in the child's circumstances or change in the program. So if that's in the law, a school just needs to get over that and accept that as a reality. And I think that the reason is twofold. Number one is we want the parents on an equal playing field with the school system when it comes to being able to advocate. The second reason, I do think that it's a punishment mechanism. That if a school system, and look, in some of these situations, the director didn't have a clue. I mean, not that the school didn't know. The principal may have known. The case manager more than likely knew, but that stuff wasn't filtering over to the special ed director, whom I typically deal with. Very rarely deal with principals because they don't have the power that they like to think that they do. And so in those kind of situations, the director, if they're, responsible for a couple, let's say 1,500 kids with IEPs, there's going to be some to where, the district stubbed their toe and the director didn't know about it because, these people didn't filter that up. And it more than likely could have been handled by the director in something that I didn't necessarily need to get, because some parents are like, well, hell, I didn't, it's been the principal the entire time, James. I didn't even know that there was such a thing as a special education director. In situations like that, I mean, that happens. And, is a parent required to sort of exhaust, all their opportunities to resolve this stuff before they get somebody like me involved? No. But I will advise parents to go back and talk to the special ed director and make an attempt to give them an opportunity to fix it. I do that a lot depending on who the director is. But in some situations, if I look at your case and I sit there and I go, you know what? Yeah, they could work this out, but it could take 6 months. And I give the parent that option. Do you want to advocate? And I'll help you walk through the process. It might take 6 months, might take the entire school year. Or I could get this done in shorter time and, overhaul your child's program in the way that it needs to be done, as opposed to you making those changes incrementally over the course of the school year, because that's the only way that a parent, if I'm not involved, is really going to make an impact on their team, is it's going to be incrementalism. Okay, and if you don't know what the concept of incrementalism is, then you need to look it up. But I mean, it's common sense, guys. It's just an idea that you incrementally will change whatever. Humans don't like to change. Socially, politically, we don't like change. Don't like change. I know we can sit there and say we like change. We don't like change. It takes thousands of years to create and solidify a culture, ethics, a morality for a society. And um, it's that way for a reason. So we sit there and we see these problems. Why do you think we reform stuff? Reform, I mean, reform is such a, I hate it. I hate the word reform. I hate it. Because what are we reforming? I mean, if there's an acknowledgement that that isn't working, why the hell are we going to keep most of those components in place and just throw more money at it with the people that are working inside of it where it wasn't working right in the first place, having more money and more control to just screw up whatever you just reformed? So like in education, oh, we reformed the hell out of it. No Child Left Behind was replaced with Every Student Succeeds Act. Okay, so we got this boondoggle under George Bush with No Child Left Behind, only to be reformed under Obama with Every Student Succeeds Act. They're basically the same stinking program, just with different money and with just different adjustments of who we're going to highlight and care about. So I'm not a fan of reform for those reasons. If we're trying something and we see that it's not working, we need to get rid of it and we need to try something else with new people, not the same people. Okay? I'm not afraid to try something new, but I'm telling you, humans don't like that. That's why we're more comfortable with reforming something, because we're familiar with No Child Left Behind. But what gets me is prior to 2000 and whatever, 1 or 2002, we didn't have No Child Left Behind. We didn't have it. So why all of a sudden do we need it now? Why do we need high stakes testing? It's continuing to create so many problems under Every Student Succeeds Act. Why do we need all this stuff? We didn't need it prior to then. I was a high stakes testing kid, and I did just fine. I think that may be up for interpretation on how competent I am, and how well this education took. But I'm just saying that when it comes to all of this on your IEP team, it is so incredibly important for you to remember that the people that you're dealing with, interacting with, collaborating with are human as well. And that if you come to the table with a whole bunch of things that you want to see changed in your child's program, when the entire education system has not changed that much from our sort of industrial way of delivering information to all children, we haven't changed that in over 100 years, guys, even though we desperately need to. I mean, it took COVID to get schools comfortable with having meetings via Zoom and Google Meets, which and getting comfortable with sort of looking at different ways and modes of delivery of information to people. That's what it took, because prior to then, I mean, guys, I was banging my head up against the wall with trying to make changes, where the school was thinking outside the box at different ways and opportunities to deliver information. So it took a big event in order to make that change. Take that into consideration when you go into your IEP meeting. And that is why the only thing that has ever worked in any society of value over time with the most amount of impact is to do it incrementally. Over the course of the school year, over the course of 2 school years. If you're in there for 21, years, that's how long your child's going to be entitled to services, then, and I understand the whole thing with developmental windows. I do, guys. I do this all the time. But I'm just telling you that the reality of the situation is, yes, I can increase the speed. I'm like steroids on an IEP program. That's my job. Okay? And also to fix things that are just in shambles. but I'm also that steroid to speed up the process. But there's a lot of you that just are not comfortable with having somebody like me involved. Great. Believe me, we're busy enough. I mean, what we can handle is a drop in a bucket with how many kids require services and that are receiving services. So if we can sit there and raise your level of understanding in how to properly and accurately and effectively advocate for your child, then great. But I'm telling you that's where you come to the meeting with your first step plan. And your first step plan is typically going to be produced through the right kind of evaluations. And, you know, I need to do another video like this and explain evaluations so that you understand that the school system may have these, you know, traditional ones that they do. Oh yeah, we'll do this and we'll do this and we'll do this. But you need to understand there's a difference between evaluations for which you have to provide consent for and the evaluations they give to all students, you know, let's say like a STAR assessment or the DIBELS, which they give to all students. Therefore, they don't need your consent. Guys, if they give these things to all students, then how is that individualized for your child who has an IEP? See, your child's a differentiated learner. I don't know if the DIBELS is going to show me everything that needs to that I need to know, or a STAR reading or a STAR math assessment, because my child has an IEP. My child, you know, is a differentiated learner. My child requires an individualized program. So that's great that you are assessing my child on these school-wide assessments that don't require my consent. But my child is not all those other children. My child requires an individualized program. So therefore, we need to identify assessments that are going to be able to identify where my child's deficits are and what programs we need. So we need to determine present levels of performance and get a good baseline in order for us to establish a good aggressive goal, and then the services that are peer reviewed to address that deficit. That's where you start. You get that information, and then you can sit there and build upon that and build upon that. But you got to start somewhere. But you chunk that information, or you chunk your attempts, and you chunk your requests. And if you do that, and if you come to the IEP team with a little bit at a time, they're conditioned to say yes. They want to say yes. The other frustrating thing with an IEP meeting, and then I'm going to end this, or with an IEP team, is that there is a natural sense of, I just think it's natural for the school side of an IEP team to appear like they have it all figured out and they have it all together. Guys, they're educators, okay? I mean, they have degrees in this stuff. And I think it's a natural human feeling or belief to go, we got this. We got this. When in reality, if they were truly honest with themselves, and I think that that's what's desperately needed on so many of these IEPs, depending on the child's level of need, especially behavior. God, especially behavior. I think it's so refreshing if an IEP team would come in there and sit there and say, we don't have this figured out. This is a mystery to us, as it is with you. But we are going to work through this with you. We are going to get to the bottom of this. We're going to bring in a third-party expert because we at this table are at a loss. And so instead of continuing to spin our wheels and then continue to have the child be spinning out to where we get a crash and burn situation, and I have so many of those. If you want to sit there and tell me the mass majority of my crash and burn cases are going to be behavior related to where the school year after year after year was either doing the same thing or because they didn't want to trigger the child, let the child do whatever they wanted to do at school. So therefore they weren't engaging the child, and therefore the child was not progressing in their educational performance areas. Well, what were they doing? They weren't being mean at all, guys. They just weren't engaging because they didn't want to trigger the child or any kind of behavioral responses. So in their mind, they were thinking, well, he's acting great at school. But what were they doing? They were now creating new behaviors that at some point somebody somewhere was going to have to address. And you know, we end up having to spend half of a school year, if not multiple school years, trying to get the child to unlearn the behaviors that the school had either purposefully or even accidentally inserted or reinforced in my client. The school can reinforce behaviors even if they don't know that they're doing it. And that's why I'm saying there's got to be an acknowledgement by the team sometimes that we don't have this all figured out. We don't know what we're doing in some particular situations, and being far more honest and receptive and getting off of that arrogant perch. Okay? Guys, I don't have it all figured out all the time. I mean, I read all the time, and I'm interested in people's input. You know, I don't. But see, that's why lawyers say we practice law. All right? And I think that just psychologically, when we have the word teach, teacher, educator, it sort of denotes that they already know it all. All right? Well, we know that that's just not true. We know that that's not true. Just on a base inner level, because we're never done learning. We're never done improving. And that's also what separates a good teacher, a good educator, a good leader, a good administrator from the bad ones, are the ones that recognize that I don't have it all figured out, but I'm loving, I have empathy, I have patience, I want to learn, I want to know. Give me more resources. Give me more tools to do that. And that's what I do, guys. I come in there because I am so pro-teacher, because none of our settlement agreements work without the educators. They just don't. So any good James Gallini settlement agreement has a bunch of teachers and a committed administrator on the other side of it. My part's this. The fact that it worked was because of the education system that I had to sit there and take the problem to in the first place. That I had to sit there and say, well, you guys aren't doing this right. Where I'm kicking them in the tail. And then in the very next breath, I'm sitting there going, but let's try this. And it's the very same people that are implementing these things. And gosh darn it, they're doing it, and they're doing it in an awesome way to where my clients are improving. But also when my clients improve, the teacher improves, the paraprofessional improves, everybody's life's lifted. Especially if I have a complex behavioral situation that is draining everybody. It's draining the child, draining the parent, draining the administration, draining the teaching staff to where they're just burnt out. So my involvement is beneficial in so many of these situations because somebody needs to come out and look at this from the outside to know where the problem is and what needs to be fixed without feeling like they have to defend, who they are as an educator. Oh, I'm competent. I've got this figured out. Guys, sometimes you just got to sit there and say, I don't have it figured out. It's freeing when you say that. I don't have it figured out. It's also a mark of an adult to be able to say and admit, I don't have it figured out. But I will. I will be receptive. I'll be open to figuring it out. So, preparing for your IEP team, that's what I recommend. Don't show all your cards. Chunk what you need to do. come in with a plan as a parent, but don't show the whole plan. Cut it down to step one. And you sit there and go, I don't know what step one is, James. Let's figure out what step one is. And I'll do another one of these videos, maybe tomorrow, when it comes to evaluations and how you get to step one.